Okay. Let's see what's on our docket for today. Give me a minute, 1 sec. All right. We'll do the Jubilee video after this. And the continuing wackiness of whatever the f this case is. I think we had our hearing on the 3rd. The hearing, I think, went very, very, very bad for plaintiff. With a lot of really goofy things being finally established really well and put on the record really well. I read through the transcript that I got because I received my copy of it. And it's not as juicy as I thought it was. It is more juicy than I thought it was. It is unhinged. Okay, it is absolutely fucking unhinged. However, so we had this hearing in a public federal courthouse, and the hearing was public, meaning any member of the public was welcome to join and sit in. Ironically enough, one of my fans showed up and sat in. The Zip Zip 45 guy did. However, immediately after the hearing, they filed to seal the transcript. And their claim was that the evidentiary hearing with regards to plaintiff's motion for temporary injunction, preliminary injunction, was conducted on June 3rd. The transcript, which has yet to be published or filed, contains highly sensitive, private, and confidential information, including personal details with regards to the identity of Ms. Doe, details concerning Ms. Doe's harm and suffering caused or because of the defendant's actions, and sexually explicit content. So the personal details, there are no more personal details. Her name is never used. The protection of the name is maintained throughout this entire hearing. Details concerning the harm and suffering, she's already publicly filed about all of these. And then sexually explicit content, these things have all been publicly filed. So all of this is already part of the public record. So this is ridiculous, but finally, the transcript of seal is necessary to protect the privacy and confidentiality of the information contained therein. Plaintiff requests that the seal remain in place for the duration of the litigation, including any appeals, to ensure ongoing protection of the identities of the witnesses. Their filings have honestly been so sloppy, I don't even think they should be granted any protection of the witness identities at this point. Also, witness identities aren't typically protected, even in these cases, even in these Cardi cases, because a witness's identity is not an inherently protected thing. Again, they're coming at this with kind of like internet rules where your name is sacred and you like, oh God, the name is doxing. But that's, I'm sorry, in court, that's just not the case. A person's name is not generally a protected piece of information. So, and the individual's reference in this testimony, as supported by Doe Williams v. Williams, they cite this case incorrectly, but whatever, which noted that 6851's purpose is to protect against the publication of intimate matters. If you actually read the case where this protection order was granted, this was just the permission to proceed under pseudonym for the plaintiff. It had nothing to do with protecting witness identities. So the citation is bad, and they miscited it, but whatever. Yeah, but anyway, so they wanted to basically keep it sealed now. This is the proposed order for the judge to sign, basically. Was Doe there in person? Yeah, they were. Plaintiff's motion for extension of time to file response, reply, answer as to the opposition. Okay, so we filed a response to their order to compel Kiwi Farms to remove videos. Because it's just, everything about it is ridiculous. You're not going to ask them to remove any of my videos, literally just for your client. You're not even going to ask for other women's videos to be taken down. You're just literally it's inappropriate. Kiwi Farms isn't a party to the case. You can't issue a court order compelling a non-party to do something, and the requesting of attorney's fees as a result of it is stupid. A court order to remove something doesn't prevent it from being reposted in the future. It's just dumb. But they filed this for an extension of time. Unfortunately, there was no response. Or fortunately, I guess, but they didn't get a response to the court, so they still had to file this. But this is the transcript being available for order. And then the judge decided to, the judge will seal the order until he gets, makes makes a ruling on it, basically. So they've temporarily granted the order to seal while he decides on what he wants to do, which isn't completely ridiculous. It would be kind of pointless to seal something after it's been made public for a while. So we just have to wait for him to, I guess, figure out what he wants to do with it. It could also be that he's just waiting to rule on this whole preliminary injunction, because the ruling on that might influence his decision here, maybe. So it is temporarily sealed right now. I have to wait for him to decide on it, which is pretty fucking annoying, I guess, because Jane Doe has had no problem posting a whole bunch of this is what I like about court, okay? This is what I like about court. When we go to talk to the judge, and when we go to talk in filings, this stuff has to be put here under penalty of perjury. So we really have to mean what we say, and we have to say what we mean. Jane Doe has had the opportunity to say a whole bunch of wild and crazy shit about me on her fucking Substack. Fuck, what was this? Oh, this. Somewhere? Wait, what am I looking for? This. So she had the opportunity to say a whole bunch of crazy shit out here publicly. This is all public, by the way, without any of this being under penalty of perjury, without being in front of a court. And then now when I finally get my day in a hearing to ask questions and respond and to give my perspective on things, they've demanded for that to be sealed and hidden from the public, despite the fact that her side of the not under oath statements remaining public, which is ridiculous, but whatever. It's not whatever. It's actually gross, and it's a fucking abuse of this system, but okay. Let's see. Response and opposition to motion for protective order. These are our filings. Oh, and this is just us arguing against these protective orders are just stupid. For why they're trying to file, like you can't, like filing protective orders for every single witness. This is just not normal. It's not the ordinary case of things. Again, if you look at like all the Cardi cases that have been filed, none of the, or at least none of the ones that I've read, the witnesses aren't protected names. The witnesses' names are just there because it's part of the case. But whatever. Declaration from my lawyer about the emails and the trying to set up meet and confers. Just the emails from this other lawyer are just fucking, just so stupid. But whatever. Joanne is just very special. Let's speak at 1 p.m. EST. Andrew, as discussed on our, she said that. Discussed on our meeting for May 12th, attached a draft and proposed confidentiality agreement and protective order regarding discovery. This draft is confidential, which means it is not to be made public or shared on social media by anyone, including specifically your client. Please advise we would like to move forward with a joint stipulated agreement. We're open to suggestion edits. Thanks. And then she says, based on your non-response, we consider our meet and confer efforts to have reached a resolution on a joint protective order to be exhausted. Joanne, it's 10 a.m. I marked up your proposed agreement and will send you our comments when I get out of my meeting. I think she mixed her time zones up because she said, let's speak at 1 p.m. EST. And then she said here, maybe Andrew mixed his time zones up. Oh, wait. Oh, no, I see what happened. She says, following up on this, please let us know defendant's position by noon tomorrow. But she didn't specify a time zone here. So she must have assumed it was EST, and I guess Andrew assumed it was PST. And so she emailed at this, I'm guessing this is from Andrew's, so there's probably 1:10 her time saying that you didn't respond, and they said it's 10 a.m. I marked up your proposal, let's go back. Yeah. I like the whole, like, if you're 10 minutes late though, she's like non-responsive. And they want like a day to, like, Jesus, chill, but whatever. Fun, good times. Funny memes. Let's see. Joanne says, although witness identities are not inherently confidential in many cases, in a Cardi case where the defendant is publicly streaming and doxing, like this is just not a word you use in court. A name is not doxing for purposes of like a court case. And witness intimidation and harassment are real and ongoing concerns. Yeah, welcome to the internet. You don't think I get intimidated and harassed? I'm not. If I direct any, well then sanction me for it. At this point, you should be praying for me to be intimidating and harassing targets because it's the only out you have in any of this, you know? Exhibit 2 has some funny markups for their dog shit filing. Wait, hold on. I'll go back and check. There are strong legal and equitable grounds for protective order that includes the confidentiality of witness identities. I cannot think of any legitimate reason that your client would be opposed to keeping certain witnesses' identities confidential. We will proceed with filing a motion. The interest is a public interest. You don't get to make, again, if you want to release like Substacks and if you want to release Twitter or Twitlongers or if you want to do like other things like that, then fine, go for it. But if you want to take me to court and you want to make me waste all this fucking money and you want to sue me for big boy dollars, then we'll go through the court process. But that process has things attached to it, like the credibility of witnesses, like people's names being attached to things. Like they've been allowed to outsource the entirety of their legal prep work to the internet, which is evidenced by the fact that they're copying Kiwi Farms arguments for all other stuff. And so I have a right to have people that are accusing me or working as witnesses in this case to be made public. This is not like a drug dealer assassination ring where your people are going to be murdered or whatever. Like, it's so stupid. The default is that the names are public and you need to provide a very compelling reason to make them private. Exhibit B had some funny markings. Wait, fuck, what? Oh, this is... Oh, is this our redlining? The name or identifying information of non-party witnesses who wish to keep their identity private. They want to seal and keep anonymous every single potential person to come forward. This is bullshit. This is bullshit. And then other confidential information, the disclosure which is likely to cause injury to the producing party. Like, this is all of this is... In accordance with Illinois law. Nice, boilerplate. They didn't change the state. Good meme. Scroll up, he marked up a typo. Yeah, I saw that. Why do they want to do this, Destiny, other than protecting the identities of people? Well, something that I have personal knowledge of is... Pixie and other people, Gisticle, are like desperately reaching out to every person. It's like the Mr. Girl shit, reaching out to every person I've ever talked to, saying like, hey, we can keep all of your information private. Like, can you please like come and testify or say that like he lied about this? Like, they were asking one person, one girl that I've been friends with, like, can you please come and testify as to like whether or not Steven has like ever told you that like we've ever hooked up before or something. It's just like, it's just ridiculously stupid shit. They're just like, they're grasping at so many straws to try to keep this case alive. And to survive summary judgment, which I'm pretty sure is against, I don't know if it's a federal rule of civil procedure, but you're not allowed to just enter random bullshit so that you survive summary judgment, which is what they're really trying to do. The interesting part, in my humble opinion, is that the part they submitted in Section 80 is a completely different document. Oh, I didn't even look at that. I do know, I don't know if I said this, I don't know if I said this or not, but they sent an order to us, the order that they were going to send to Kiwi Farms, they sent a motion to for a court order, and that court order included, the motion for the court order included us paying attorney's fees. When they sent us the copy of that motion, they didn't file the same motion that they sent us. They sent us a copy, and then they said that we agreed to it, and they filed a different motion with the court saying that we agreed to it that included paying them attorney's fees. What the fuck? It was like, hello? No? Why would you claim that we consented to that? We absolutely didn't. This is not the one that you sent us. Isn't that sanctionable? I don't know what's sanctionable or not. Hopefully a lot of this is, but who knows? Question mark, question mark. Do you have, does anybody have a link to that? Or I can go look for it, actually. I guess it's funny enough to look at the links of. You showed they deleted and added one point, yeah. So here's them. This stipulation between plaintiff and non-party lockout regarding limited submission. Okay, to the Honorable Court. Plaintiff Jane Doe is a party to this. Non-party lockout is the company which owns and manages the Kiwi Farms, an internet forum available at link to Kiwi Farms, and it is not a party to the litigation. Plaintiff has submitted a proposed court order titled Proposed Order Granting Plaintiff's Motion to Compel Lockout LLC to remove videos of Jane Doe that requires certain compliance by non-party. Whereas plaintiff has requested the non-party acknowledge and agree to the court's jurisdiction. So they're basically begging Null from Kiwi Farms. They're saying like, hey, can you please avail yourself to the jurisdiction of Florida so that you can be entered in a court order here, please? And so he agreed. Non-parties agreed to voluntarily submit to this limited jurisdiction under the terms stated herein, but only under the terms stated herein. Now, therefore, it is hereby stipulated and agreed by and between plaintiff and non-party, subject to the court's approval as follows: limited submission to jurisdiction, so they're only going to be available for this particular case and for this particular thing. And then the scope of submission: non-party acknowledges receipt of the proposed order and agrees to comply fully with its enforceable terms, including but not limited to removing the content hosted by the enumerated URL, so just for Pixie stuff. But then I think they also include opposition promotion comes now. Oh wait, this is a different thing, I think. Oh, this is just what they want. This is the stipulation we played about. Okay, that was it. Okay. What federal rules of civil procedure did they try to file this stipulation under? I don't even know if they put I don't even know if they put an argument in here for it. All of it is like so goofy. It's just like it's jurisdiction only for this order. Yeah, not the case. Yeah, I agree. It's very limited in scope. Yeah, it's just stupid. But the funny thing is, okay, and here's the funny thing, okay? Here's the fucking, and fuck all this guy. Also, fuck these people. Do you remember what I said about this whole court order business? I said that this court order is so stupid because, like, why would you tell somebody, hey, if you just get a court order for me, I'll agree to do this thing, right? Well, if you're going to do it and you agree to do it, why do you need a fucking court order for this? I don't understand what the point is. Like, why not just do the thing? You don't need a court order if you already say that you're going to do the thing, right? There's no, at that point, you don't even need one. Hold on. So fucking So Null posts, so FYI, when her attorneys called Hardin, who I think is his counsel, and asked for a bunch of shit deleted, we said, go get a court order and we won't oppose it. Why do you even need a court order then? I think they even mention that we don't oppose it. I just want the order so I don't have to be responsible for moralizing decisions. But what do you mean? You've already made yourself available for jurisdiction in this jurisdiction. So why do you even, you already did like moralize it, right? You decided to allow yourself to come under the jurisdiction here. So you've already made that decision. So what are you even talking about? And you said you're not opposing the order. So what is the point of this? Destiny opposes the request in part because he's trying to goad her into suing us. I'm not trying to goad anybody into suing Kiwi Farms. If anybody was going to do it, it would have been me. But I'm just saying that if she wants to force you guys to do something, then she should sue you. And honestly, Null, for the health of his website, should agree with that. Null shouldn't make it standard practice if you care about Kiwi Farms, that Kiwi Farms will just randomly and arbitrarily agree to any court order from somebody who's not even brave enough to sue the site, right? So Destiny opposes the request in part because he's trying to goad her into suing us. I'm just saying if you want to compel Kiwi Farms to do something, they have to be a party to a case. Sue them. In part because her attorneys got really greedy and asked for fees in an order that doesn't really entitle fees. True. This is the guy that leaked everything? No, Joshua is the owner of Kiwi Farms. He just doesn't like me. And he likes to post my thread a lot. Attorneys got really greedy and asked for fees in an order that doesn't really entitle fees, but more importantly, isn't technically legal because Kiwi Farms is not in the jurisdiction of Southern Florida. So we agreed by extension that I would explicitly avail myself to its jurisdiction for the very specific purpose of receiving this order. I'm basically having to ask for it at this point. So why not just remove it yourself? And then he says, I'll leave why up to your imagination, but they were calling Hardin literally every 15 minutes, asking what my progress was on signing the aforementioned jurisdiction agreement, then also basically started begging that I take everything down before I even get it. I'm not particularly eager to be dragged into this, so I've done it. My expectation is that if we did get dragged in, she would get her court order regardless, and there's literally no point fighting it. Destiny really wants me dragged in, though. But yeah, if Destiny just managed his huge win against her, he might get a more impressive PR disaster in the aftermath. I don't know what the disaster is. So at the end of the day, he did remove it. They removed everything. He didn't need a court order. He never needed a court order. So why did we waste all this stupid fucking time on this when he had the ability to take it down, and then he did take it all down on his own? Like... So what a stupid fucking waste of time on all of this. Null's reasoning is very stupid. No, because I will tell you what Null's reasoning actually is on all of this. And it kind of makes sense if you think about it. Null doesn't want to take shit down on Kiwi Farms because Kiwi Farms is a huge repository of gossip and juicy information. And Null doesn't want to have to take anything down unless somebody gets a court order for it. And he knows that most people aren't actually going to get a court order to get stuff taken down because most people aren't going to file a case and all of that. So in Null's perspective, he's like, yeah, you know what? I'm not taking shit down unless you come with me the court order, because he knows that most people aren't going to do that. So then it allows them to leave shit up on the site. However, if there's an actual court case that's proceeding, in my opinion, and I see this on very light ground because I haven't done the case reading into this, but in my opinion, it seems like Null probably exposes Kiwi Farms to a whole bunch of legal to criminal potentially and civil liability by him knowingly hosting all of my revenge porn, because he's made it clear in multiple posts that he has personal knowledge because, one, he's been emailed by my team saying it's revenge porn, and two, he's made public statements about it being revenge porn, but he maintains it on the site. I think that probably hurts a lot of your Section 230 protections that makes you immune from being directly sued rather than having members of your site being sued. And I think he realizes that. I think that's why he's like, listen, so I removed all this shit. I don't want to be part of any fucking court case, because normally he's a big baller and he's like, oh, you don't like it? Then fucking sue me. Talk to my legal team. But now he's like, okay, well, we didn't get the court order. They're crazy. We removed it all anyway. They probably win regardless. Because he really doesn't want to be dragged into a case over this, because calling into question, I think his Section 230 safe harbor stuff would probably be really scary for him, is my guess. I could be wrong, but that's my guess. Remember, I haven't read a lot of like case law or shit in this area, so. TJ, that's the same thing that the leaker said to me, that Solo said to me. It's interesting you said that. At Destiny, Null is butthurt that you didn't post a video of your conversation with him. That's literally his entire reason for being this bitter. He said so multiple times. If that's true, that's funny. I think I told Solo, the leaker, I think I told him directly. I was like, oh, if I didn't post a video, it's because August didn't. I don't decide what videos get posted or not. So if that's actually the reason, I guess it's kind of funny, but. Do they remove your stuff too, at least? I believe the whole Solo post got nuked. That whole post that he did. I don't know if anybody else has posted stuff. I haven't gone through looking for everything, but. So that's all gone now, I guess. And then we have, this is our most recent filing. We're back on that meme shit. I don't know if they're just like really desperate to go to trial. I don't know what the plaintiff's strategy is at this point. I don't know if she's like, if she thinks that if she goes to trial, maybe she can cry in front of a jury and win, maybe. Or if she just thinks that I'll settle because I don't want to waste the money on it. I have no problem wasting money on it. Or if I don't know what the rationale is. I truly don't know. I'm not sure. Or if she thinks there's still more evidence out there that she just will be found. Maybe she just has to believe hard enough and it'll materialize. But come now, plaintiff Jane Doe, and by and through undersigned counsel files a reply to defendant motion for entry. Okay, so this is against our motion to compel. Or we're opposed to her motion for the order to compel Lolcow LLC to remove videos. Okay. More meme arguments. So now they're fighting on this subject matter jurisdiction a lot. Remember, subject matter jurisdiction is the thing that gives this court the ability to hear the case. The first claim is a federal claim. That's the subject matter that gives them jurisdiction over the case. We're arguing they have no case under the first claim because they have no evidence that anything happened while this law was in effect, which they have yet to produce. This is a fatal flaw in a complaint. If they cannot find something for this, then the whole case gets dismissed and that first claim gets dropped completely. So now they're having to fight on this a lot in every motion, I would imagine. Defendant erroneously states that this court lacks subject matter jurisdiction over the claims involved in this action, which arise out of federal statute 15 U.S.C. 6851, civil action relating to disclosure of intimate images act, Part E. The defendant takes this misguided position based on his claim that the one and only time he shared this video was prior to the statute being enacted. Plaintiff has presented this court with competent evidence that directly rebuts and disproves defendant's assertion. The court has subject matter jurisdiction because the claims arise under 15 U.S.C. 6851. The burden of proof to establish subject matter jurisdiction is on the plaintiff to support their claims with regards to jurisdiction by competent proof, and then they just go through legal argument for that, obviously. So the statute that they're claiming, which became law on October 1st, 2022, allows for an individual to file a federal civil suit against anyone who discloses intimate visual depictions without the consent of the person depicted. Disclosure is defined as an act to transfer, publish, distribute, or make accessible. This is a broad definition, and in construing a statute, the court must begin and often should end as well with the language of the statute itself. So for CARD purposes, transfer, publish, distribute, or make accessible, this doesn't mean you have to do it in a public manner. Sending it to a single person does count for CARD stuff, okay? That's important because the later claims that they cite do not count as just singular transfer. You have to publish it on an internet public website, okay? But law didn't come into effect until October 1st, 2022. As well with language, okay. Publish means to disseminate to the public, means to give out or deliver, especially to members of a group, and to make something accessible means to make something capable of being reached or seen. I don't know why they're quoting this case. I don't need to, but whatever, okay. Paragraph 23 of the complaint. The defendant has admitted he did disclose such an image, yet claims this court lacks subject matter jurisdiction because the actual action of sending the link containing the intimate depiction was done prior to the statute's taking effect. The complaint alleges that not only did the defendant share the video with an individual who goes by the screen name Rose, but in paragraph 23, it also states the defendant shared the video with another individual just a couple months prior to this lawsuit. So this claim here, I don't know why, maybe they're just allowed to do this forever. This is the claim where they said, somebody messaged me and said that my sister got a video of me, maybe. It's a double hearsay. But they said that this person has since deleted their account, and they have no evidence of that. Okay, but I guess they're going to continue to bring this up. This is bullshit. This is totally fabricated and not true. But okay, you have a sister? No. Plaintiff claims a supporter messaged her, and the supporter said, I think my sister got a video of you, and then that's what they said. But they deleted, but they said they've since deleted their account. She repeated this claim, by the way, in court, which was hilarious. In the defendant's answer, this allegation is denied due to lack of information and or belief, because they don't have any information about this. They were just told a thing by a random person who has since deleted their account. This denial and the lack of any evidence which contradicts the claim, how can I possibly contradict that? How can I prove that negative? How can I prove that I haven't sent a thing? I don't even know how I could begin to prove that, but okay, funny, okay. Somebody said, Destiny, why is everyone going after you so self-destructive and absolutely uninhibited in their pursuit of taking you down? Mr. Redacted, Lav, Gistigal Doe, and many others are so hell-bent on dragging you down, even at the expense of their own well-being, which is so weird. What's happening here? The only guess I can give is that there's so much public pressure to come out against me, and there are so many other people who are willing to gaslight you or to say that like I'm a horrible, evil, crazy person, even if we've supposedly been friends for 5 or 6 years, that maybe people start to believe it. That's the only thing I can think of, because yeah, like there is a world where she has potentially a singular okay-ish claim against me, but yeah, I don't know why, but they always become just unhinged, and then I don't know. This denial of lack of any evidence, which contradicts the claim made in paragraph 23, is insufficient with regards to making a showing that counters the claims in the complaint and fails to establish the defendant's position that this court lacks subject matter jurisdiction. Like, I don't even know, is this paragraph 23 of the complaint? Is that exactly what they're referencing? Let me just check. Paragraph 23. Tell me what evidence I'm supposed to give against this, okay? Tell me, okay? On January 20th, right after plaintiff announced publicly that she would sue Bonnell, one of his followers reached out to plaintiff and told her that Bonnell had sent the video to her sister about 2 months earlier. The follower informs plaintiff that she believes Bonnell is still sending her sister sexually explicit videos of other women without their consent. I have no idea who this is. Pixie doesn't know who this is. They've provided no evidence of this, no screenshots. I don't think. Oh, maybe they did do one screenshot of the DM on January 20th, but there's no follow-up, and I think they've said they've deleted. Yeah, and then in another filing, she says this is her follower, not one of my followers. But how am I even supposed to counter that? I don't know who I don't think this is even real. I think this is a completely bullshit claim. It's just totally fabricated. But, okay. But that's paragraph 23 from the complaint. So, okay. And now we're moving on. Okay. So now we're going to try the next meme argument. Okay. We have no factual information, but let's go to the next tier of meme arguments that we're lifting from Kiwi Farms, by the way. Okay. All right. Additionally, the evidence shows that the defendant sent the video to Rose on Discord. It is plaintiff's position, which is supported by evidence, the defendant did so either as a media attachment on Discord or as a video linked to a Google Drive. If the video was shared on Discord, then the platform automatically creates a link and anyone with access to that link can access the video. Every video sent on Discord automatically is embedded with a media attachment link. This link is a live link. Anyone with this link can view the video. Defendant has demonstrated knowledge of this feature because he routinely shares Discord media links in his public chat. The same analysis applies to both sharing the video through Discord or sharing the video as a Google Drive link. So there are two huge issues with this. One, philosophically and technologically, and two is self-defeating, okay? So the first one, technologically, doesn't make any sense. So the argument they're running with, and again, Kiwi Farms try to float this, and again, I don't have to argue these retards online, and I think Gistigal and all them try to do the same thing, because I can just, thank God, because we can just argue in a court with facts where you have to follow a singular line of thought. Somebody is saying that, let's say that you send me a digital file of a sexual act that we've done, okay? And then let's say instead you send me a Google Drive link to the file. Well, if you send me a Google Drive link to that file, then you're basically always continuously resending me that Google Drive link. However, that exact same line of logic applies to literally every single digital file that is sent. I could send you I could text message you a file, and that file lives forever in your text messages. Am I continuously resending you a thing in your texts because it's always accessible there? It doesn't make any sense. Now, one could argue, well, hold on, it's different. Somebody could just take the Google Drive link that you've sent and they could forward that to the person instead, in which the counter is just, but they could do the exact same thing with the digital file. Somebody could take a text message image that I've sent and copy the image and just send that as well. There's no argument here. There's no case law here that they can cite. There's no, philosophically, technologically, it doesn't make sense. Every single digital thing is infinitely transferable. It's a digital file. Everybody can always do that. There is no case law that they're going to find that's going to show that if you send a link to something, then that counts as you perpetually and infinitely sending it. That's just such a stupid argument, number one. Number two, the argument is self-defeating, because if that is the case, then I would just say easily that, oh, well, in that case, plaintiff consented to literally any transmission of anything that I've ever sent of her, allegedly, because when I sent her the files she requested from me, they were Google Drive link files. So in that case, it's the same thing. Then are we saying that if we know that those links are quote unquote live all the time, that she infinitely consented to the links being, like, it's so stupid. Could they argue that the entire share happened instead of using the Google Drive share feature that only allows the account to access it? Even if you wanted to make that argument, let's say that I've shared a link with you, and let's say that I've made it so that that link is only copyable but not shareable. You could just download the file and rehost the exact same thing on Google Drive and then send your own link. Or I think in Google Drive, you might even have like a copy to my Google Drive link and do that. It's just, this argument is so stupid. You need to find evidence of me resending that particular thing. It can't just be this weird Kiwi Farms argument of, well, if you send it one time on a link, then technically that means you're infinitely and always resending it. This is retarded. This is the dumbest possible fucking link. Or this is the dumbest argument you could ever make. And again, there's no case law supporting this. This is just so stupid. But The evidence clearly points to defendant's predatory and abusive behavior, including his pattern of sharing videos of the same nature and in the same form. Quote, I just throw stuff into Google Drive and link from there, end quote. Defendant admits that he kept these types of intimate depictions on his Google Drive and would share a link to show the content. I believe personally one of the reasons why they want to keep the hearing transcript sealed is because the judge asks Pixie questions about this, and she admits eventually after some questions, he's like, yeah, he did share me stuff on Google Drive. And I think the judge even asks, he's like, so then did you not think that he would share stuff, continue to share stuff on Google Drive? And I think she just says yes. It's like, yeah. So, yeah, what like, defendant claims that the sole time he shared this link was on April 10th, 2022. Defendant's evidence with regards to the initial disclosure does not sufficiently counter the claims that the disclosure was in October. To do so, he would have to provide the subsequent logs until after the date change, which he has this far failed to do despite his claims that they are readily accessible and in his possession. So they've never asked, I can provide all of those logs. However, this is not a real argument. This is bullshit, and they know that it's bullshit. Because if you go to Kiwi Farms and you look at where they ripped the images from this, you can see all the logs posted. 15/08/2022, 21/07/2022, 18/08/2022, 13/04/2023, 27/10/2022, drool emoji. What, like, unless you're going to argue that there are 28 months in the year and I've just forgotten all those months, like, it's very clear and obvious that the date is formatted in a European date format. And you know that. You know that when you ripped the logs because the site shows all of these other screenshots. And if you didn't know that, if you couldn't figure it out from those context clues, in the final screenshot, it literally says at the bottom, time zone UTC +0. It literally says it at the very bottom. That is a European time zone. So no, the onus is not on me to prove that's bullshit. Everything posted in these logs, all the timestamps were clearly and obviously in a European date format. Okay, like, this is a non-argument. They're proffering something that is they don't even believe this. It's so dumb. But even if we were to believe this is true, Ms. Doe is not asking this court to apply the statute retroactively. Given the defendant's conduct in making this content continuously available through this link for years satisfies the statute and controls subject matter jurisdiction. Where is our case law? Where are links to anything ever substantiating such a ridiculous argument? Because in that case, this is a self-defeating argument, because then all of this content was made available with knowledge of plaintiff because the same link existed on her Discord. Like, this is such a stupid argument. Like, actually, when you send anything, you're continuously and constantly sending it forever. What? They legitimately try to get it sealed just so they can slander you a little longer. Yep. Ms. Doe is not the only victim of the defendant's non-consensual sharing of videos. In fact, others have alleged the defendant disseminated their videos through Google Drive links as well. I like how we also keep bringing up like other people who aren't related to the case, but okay. The defendant's use of Google Drive for this kind of content is well documented. Yeah, because plaintiff knows, and specifically mentioned by the individual who gained access to the videos, which were leaked. The act of making, yeah, but it would have been, if it would have been a phone, it would have been the exact same thing. I think the judge, thank God, I think he actually asks this. I think the judge literally says, oh my God, there's such a good quote that he says towards the end where they mention that, like, oh no, this link is available, like you could do this, whatever. And then the judge says, but this was a text message. It's not like he published this publicly on a Substack, right? Which was fucking hilarious because it was in reference to plaintiff publishing a Substack. Oh my God, please let me read this transcript. It's so good. God, it's so good. Please let me read this transcript. Don't seal it, judge. The act of making this type of content accessible without the consent of the individual portrayed in the sexually explicit video or image or video is exactly what Cardia was enacted to prevent. That means that every single person that has ever done anything prior to this law in any digital format, all of these people would be, it's just stupid. It's just dumb. Can you not read it even after you bought it because it's temporarily sealed? No, I reread the whole transcript. I just can't publish it, or I don't think I can do a public reading of it. What's the difference between you recollecting what the judge said and reading the transcript? Well, I have recollections and notes. They haven't gagged me on talking about the case. I just can't read the transcript. So did she share nudes, Destiny's nudes, with her BF or not? I don't like to call them nudes. They're videos of the two of us. And yes, she shared all the material that we made with her boyfriend. And I don't believe she ever told me that or asked me explicit permission to do so. Although, I mean, I would say, and I said as much to the judge, I mean, I wouldn't have objected to it, but if we're going to go with the explicit verbal consent needed to send every single file, then, well, fine, I didn't fucking consent to any of that, but whatever. By hosting the content on these links, whether it be a Google link or a Discord link, the defendant was making the content accessible for years after the passing of the statute. Not only were the videos accessible through November 2024, when an individual by the screen of Solo Tiny Leaks posted them on the internet, those links were active and accessible up to January of this year. Thus, this court has subject matter jurisdiction. Again, like that would be the same, that would be true of any digital file. But again, it's from one meme argument to the next meme argument to the next meme argument to the next meme argument. Okay. Ms. Notice provided this court with the declaration of penalty of perjury as a witness, or of a witness, which was filed under seal. This declaration states that on or about November 3rd, 2024, the defendant shared the section-specific video depicting plaintiff with the declarant. As a result of the defendant deleting all those messages with declarant, the exact date of the sharing is unknown. However, we do know, oh wait, hold on. ECF number 492. Ooh, this was such a good question by the judge. So this is for, I can't say the real name of the person, but this is for screen name Abby MC, okay? Claims, so listen very carefully, okay? Listen to this very carefully. She claims in her thing, she says that I recently reviewed my Discord account and realized that Destiny deleted all of his direct messages to me on the Discord platform, including the sharing of the video of Pixie. I have retained copies of all of my messages to Destiny, as well as my messages to other people about his non-consensual sharing of sexually explicit videos. The only thing that Abby MC produced, however, was a message from her to another girl saying, Destiny sent me videos of him and Pixie and Cherry or whatever hooking up. The second person of which no videos exist of that, so that's impossible. However, I believe that when we were in court, the judge asked her explicitly, have you seen, it was either the judge or my lawyer, asked her explicitly, have you seen evidence of Bonnell transmitting the video? And she said, yeah, Abby MC showed these things. It's like, no, have you seen evidence of that, of him transmitting the video, not just her talking about it? And they said, no. That means that this is bullshit. Abby MC is either lying about having saved all of our messages, or she was unable to produce any proof and she was just talking shit with a friend, which is what she was doing. She was just talking shit. It's like, oh, Destiny sent me all these videos, blah, blah, blah. And she was probably just lying or guessing or whatever, making up bullshit. Because I think I Control-F'd all my messages with her, even her. I don't think we ever mentioned that person's name a single time. Pixie's name. I don't think it ever came up a single time ever. I don't even know if I've ever talked to her about her. So, but they admitted in court that this witness hadn't even shown them evidence of me transmitting anything to this person. So it's just bullshit. I would say it's perjury. I'm pretty sure it is perjury. At the very, very, very minimum, it's lack of due diligence on the side of the plaintiff to not verify their fucking witnesses. And they tried to apply additional pressure on me because I got a demand letter from this Abby MC person who's supposedly retained by the same law firm saying they were going to sue me unless I settled with them pre-trial for $500,000. $500,000. Not only did they send me that demand letter saying that she had retained the same litigation firm for a case against me, of which never materialized, when we tried to subpoena her, she dodges all of the service requests. And then when we contacted their law firm and tried to service subpoena, they said, oh, sorry, we can't accept service on behalf of her. So what? Did you lie about having her as a client? Did she drop you as a client, but she stayed on as a witness to this case? Can you not say, like, it's bullshit, but okay, good one. As a result of the defendant deleting all of his messages with the declarant, the exact date of the sharing is unknown at this moment. However, we do know for certain that this could not have occurred before the year 2023 because, as defendant has admitted, he did not meet declarant until 2023, well after the statute being law. This doesn't even make sense. Are you saying that I could never have transmitted a video to somebody before meeting them in person? That's not logical, because you can clearly transmit stuff digitally to people before meeting them. What is this? It doesn't even make sense. Ms. Doe also provided this court with messages from November 3rd, 2024 between the same declarant and a friend. In these messages, the declarant tells her friend the defendant did in fact share the video plaintiff with her. Like what? Then where's the evidence of that? You have no evidence. You just have her stating these things. The same person who, by the way, because, and this might sound mean, but her character is going to come up as part of a witness because you're going to assess the credibility. This is the same person who's told Darius and a million other people over and over again. And I think it's publicly said, I was super drunk the whole time. Like I did a bunch of crazy shit that I'm not proud of. And I was, blah, blah, blah. Like I don't believe any of this. This is all bullshit. It is bullshit. I know it's bullshit because I checked all the fucking logs. The mass publication of this video, which occurred because the defendant continuously made this content accessible, occurred on November 29, 2024. But that means that, again, plaintiff would have made it all accessible as well because plaintiff also has a link to it. But okay, which means the declarant would not have known about the existence of those videos at the time she sent this message if it were not because the defendant did in fact share the video with her. But we have no proof that she even knew those videos existed. She literally could just be making shit up. Like she literally could just be saying random shit, which it seems like she was because one of the videos she alleged she saw doesn't even exist. And she has no evidence of me transmitting any of this stuff to her. The evidence which has been submitted is more than sufficient to show that the defendant shared the video with the declarant after the date in which the statute was enacted. The declaration and the evidence submitted in support thereof serve as another avenue for the court's subject matter jurisdiction over these claims. Despite defendant's claims of being continuously harmed by the publication of these videos on Kiwi Farms, his alleged extraneous efforts to have these videos removed, which he was recently forced to admit, was his assistant sending a singular email to the website owner. I'm sorry, what do you want me to do, beg? Joshua hates me. I know that he fucking hates me. And he literally put on his site that you need a court order of anything taken down. I'll send him one email to put him on notice, but then after that, what? You think sending 10 emails is going to help? And Lawcal LLC is agreeing to remove these videos if directed by a court order. Oh, so then my emails wouldn't have mattered. Good job. Defendant now takes up issue with Lawcal LLC status as a non-party in this case based on an alleged lack of jurisdiction by this court over the non-party. No, my big issue is that you won't agree to have all my videos taken down because we said we would accept that, and they didn't do that. They only wanted a couple taken down. And they wanted to charge us money for it? Get the fuck out of here. Attached here too is Exhibit A, is the stipulation of Lawco LLC to subject itself to this court's jurisdiction in regards to the proposed court order. Thus, this court does have request for relief. Defendant claims that removing these videos is arbitrary relief, even though he contradictorily claims that he has tried to have them removed to no avail and continues to victimize himself with regards to the alleged damages he is now facing because this video was posted. I understand it's a court case and you're trying to win it, but I'm sorry. This is just the most disgusting, grody, like just absolutely... It's just the most gross behavior that you could ever, like even in a court filing. I'm sorry. Like, eat shit. This is so disgusting. He victimizes himself. He's victimizing himself. Get the fuck over yourself. What a gross thing to say. The reason why the court order doesn't do fuck all for me is because, one, all of this shit is already blown up to the corners of the earth, in part because of plaintiff's obsession with publicizing as much about her sexual exploits as possible. And despite her... desire to proceed under pseudonym, she had publicized as much about this as she possibly could have. The court order doesn't help, though. People can still republish shit. You need an injunction at that point, which is why in my New York law firm, I wanted to take, probably Kiwi Farms would have been a party to the case so that I could have got a permanent injunction to prevent anything in the future from being posted. The need for these videos to be taken down is evident. And also, you're not even trying to take down all of my videos, just the ones involving plaintiff. The need for these videos to be taken down is evident, and the situation speaks for itself, and the fact that the defendant requires an explanation as to how having these videos removed would constitute proper relief is truly appalling. Because the proper relief that you would seek wouldn't be a court order, it would be a permanent injunction. The relief requested is but one step towards correcting the wrong caused by defendant to plaintiff. The wrong that was caused when somebody who wasn't me uploaded these to a website that I don't control. Give me a fucking break. While defendant may be comfortable with having this type of private content on the internet, like, eat shit. Are you serious? Plaintiff is not and continues to suffer extreme emotional distress because of the publication of the apparently not, a concept everyone but the defendant seems to understand. Like, eat shit. This court case has been for how long? Right? You guys were sitting on your thumbs doing fuck all while apparently your client was apparently suicidal. It took you a month and a half to file for a TRO that got tossed in large part because of the staleness, because of how long it took you to file the temporary restraining order. You're telling me that it took you more work to write up the restraining order than it did for the fucking complaint? Why wasn't the TRO submitted the same day or the day after the complaint was submitted? It's a TRO. It's an ex parte request for enjoining behavior. Why are you waiting so long? We're now 6 months, 7 months, 8 months into the leaks, and now you're saying that there's irreparable harm that's being suffered? How has it taken so long? Bullshit. Additionally, the defendant has continuously ridiculed and mocked Ms. Stowe after the video was leaked to his followers on his online platforms. I'm not like ridiculing her for the video though. Nice trying to combine that there. I'm ridiculing them for the behavior that they're displaying in court, including directing his followers to the Kiwi Farms site. Again, that's another super fucking gross mischaracterization of me complaining that all of my revenge porn is still being openly hosted on Kiwi Farms and none of the commentary bros or anybody seem to be talking about it or give a fuck about it, but okay. Granting this order would be proper as it would serve to prevent imminent irreparable harm to imminent and irreparable, they say 7 months into the case. What does imminent mean? What does irreparable harm mean? The imminent irreparable harm to that is that Ms. Stowe's mental health and her quality of life. Defendant opposes the plaintiff being awarded attorney's fees because he claims there was a failure to meet and confer. In fact, defendant's own attachments show there was an attempt by plaintiff to reach a solution to this prior to presenting it. Yeah, and you guys rejected it because you wanted to keep my revenge porn posted on Kiwi Farms. Defendant was initially willing to agree to the motion until plaintiff informed them that the additional links they sent did not include any content which contained Ms. Stowe. Yes, my revenge porn. Plaintiff's request for attorney fees does not arise out of bad faith, but out of the fact that plaintiff spent a considerable amount of money in having her attorneys coordinate the removal of this video, which was... No, you didn't. A considerable amount of money to say, can you take down this link? Bullshit. Okay, anyway, sorry. Anyway, that's where we're at right now on this. This is their proposed order. It's fucking whatever. Praying. The best case scenario is that the magistrate judge recommends tossing the case because of a lack of subject matter jurisdiction, even though technically that request isn't before the court. But if he doesn't, then we just continue to float on through discovery until we can file for summary judgment. But yeah. I know nothing about U.S. law. Is it possible that they would have to pay out something for bothering you for no reason? Maybe, if it's sanctionable behavior, if there's like anti-slap shit. I don't know the process for how any of that applies though, so. Was this not summary judgment? No, this was fighting over the preliminary injunction. That's what this hearing was for. But I mean, you can see that like subject matter jurisdiction stuff is starting to come up a lot. Thankfully, thank God now. Why doesn't Doe want your revenge porn, including that of other people's, taken down from the site that she's in contact with? Probably because in their filings, it's very important for them to make it look like I wanted all of this to happen, that I was directing it, that I'm getting off to it, that I enjoy having my privacy and everything destroyed on the fucking internet. So they're not going to agree to having any of my stuff taken down, because if that's being taken down, then it kind of makes it seem like it shouldn't have been there, like I was some kind of victim of any of this. But yeah. Anyway. Pray to God that hopefully soon the transcript they roll on that motion and it's not sealed.
Or
people keep saying Discord links only last 24 hours. I don't know why you're saying that. I don't think that's true. I don't know where you guys are getting that from. I don't know if you're just making shit up or if you like don't understand technology or... why haven't you motioned to get it tossed? Well, initially, in the pleading stage, a motion to dismiss would be if you have to assume that all of the factual allegations are true, and then whether or not the complaint has any prima facie like meets the requirements for what's being listed by the plaintiff. So in the beginning, she said there was evidence of me transmitting the video, and so for a motion to dismiss, the judge would have to just consider that to be true, and so it would fail. It would survive a motion to dismiss. A motion for summary judgment allows a judge to, I don't know what the exact standard is, but the judge can start to consider some evidentiary things in the motion for summary judgment. They cannot dispute they can't dispute legitimate factual disputes. But if there's like some bullshit, they probably could. So like this is in my opinion, okay? In my opinion, like that the Abby thing is bullshit. That would get that would be a thing where in summary judgment, the judge would look at like, this girl hasn't provided any evidence of this. It's just her talking to a friend about a thing. This is bullshit. But in my personal opinion, if Abby had come into the hearing to testify on the preliminary injunction hearing, and she would have said, I remember, Judge, I remember him sending this to me. I remember getting it. I remember seeing this. Then I think that that would probably be more of a material fact that I don't think would be tossed at summary judgment. I think at that point, I think the judge would be like, she's willing to testify to this, and she said this. Like, this is probably for a jury to decide. So, but. Destiny, they do. They'll link themselves, but not the file, please just stop talking, stop. If you send any media file on Discord, you can go back as far as you want. If you right-click that file to open in browser, you'll get a link to that file, and that link is live for as long as the media is uploaded to Discord. I don't know what else. I don't know what other things you guys are talking about, but. It's true since late last year Destiny, but doesn't apply to retroactive posts. Those links now change every 24 hours. Oh, like they change the actual link itself does? Oh, so like they just shuffle around the links, but the content is still live, but then they give it a new link? Oh, that might be true. Maybe. I've never tested or checked for that before, but...